This is a subject which could go on for a long time, and I will try to make a few comments. Many of the substantive points I make were made in different ways yesterday, but I look at some of it in a completely different perspective. And so first what I want to address was the statute, the actual establishment of the tribunal. And I would suggest that there were three missions that were identified. One is to prosecute those most responsible for the atrocities, to facilitate reconciliation between former combatants, and to restore peace in the Great Lakes. Now, when you look at those missions, at least two of them are political. And you put yourself in the context of 1994, where you have the atrocities destroyed the judicial infrastructure of Rwanda, either by extermination or by flight. Now, and I think of politicians at the United Nations wondering how to achieve these political objectives. And they chose a judicial process. Now, when I look at the cynicism prevailing in the world, and I reflect on that, I find it a matter of great inspiration that the politicians would believe that those political objectives could be attained through the exercise of a judicial process. And I see that as fitting into a much broader philosophy of life. Because when you look at the institutions like the World Bank, for example, their policies are affected by the belief that fair and independent judicial processes contribute to economic development and social stability. And so that's the first thought I throw into discussion. Because you look at Rwanda 19 years after, and I suggest that the choices made at that time by the creation of a judicial process has contributed in those ways to this economic development and social stability in Rwanda through the exercise of the independent judicial process addressing the atrocities. Now, another thought I throw into the impact. And you look at the impact on domestic jurisdictions in different ways. And I see, for example, direct impact on domestic courts, not only in Rwanda, but not only in Rwanda, but through the process of the referral of cases. Now, building judicial capacity in countries affected by mass atrocities, where those create inability or unwillingness to bring perpetrators to justice, has now become regarded as an important role of international court systems. And it is in fact a governing principle of the work of the International Criminal Court. I suggest that the ICTR was a forerunner to this. And I get just reference that the process by which Rwanda moved from a country whose judicial system had been destroyed by the atrocity to one where its judicial system was judicially described as meeting international standards is largely due to the approach of the referral of cases. Now, I'm skipping because I don't want my moderator to. but there are lots of thoughts that I have here. But what I wanted to jump to was when the referral of cases to Rwanda was determined to be judicially supervised. The case law interpreted this to mean that referrals would only be ordered where there was a legal framework that criminalized the alleged conduct of the accused involved, that provided an adequate penalty structure, that provides appropriate punishment and prohibited the death penalty. 3, that secured conditions of detention that accord with internationally recognized standards. And 4, that guaranteed to the accused a fair trial. Now, Rwanda was initially unable to get either extradition orders or transfers from the ICTR. And it was recognized by all parties that significant capacity building was required in order for Rwanda to become eligible. Now, what is little known is that the Office of the Prosecutor worked with Rwanda to try to achieve those standards. And when the Office of the Prosecutor concluded that it had succeeded, it filed the first applications for referral. But unfortunately, judges are not prosecutors. And there was a different perspective from the judiciary. And the first hurdle was the issue to which the international, the penalty structure. Now, Rwanda had to abolish the death penalty. And the fact is, it did, by statute. Now, I heard discussions about this yesterday. And I must tell you, I had a completely different way of looking at it. When I think that the people who control the government, who control the parliament of Rwanda, were the victims of the genocide being sought to be prosecuted, and the victims of crimes of that enormity decided to abolish the death penalty for the perpetrators of the crime. I think that is massive. It requires, to my way of thinking, regardless to what cynical thoughts you may have that people did it, that some people did it because they wanted to achieve referral of cases, Parliament could not have passed that without a spiritual transformation of the community. And I suggest that that is evidence that reconciliation was at work in that community. Now, when you look at detention facilities, now, under the supervision of the ICTR and UN, Rwanda invested considerable funds in improving the physical conditions of prisons. Known fact. But the court said that is not enough. It required them to make legislative changes to prohibit solitary confinement. And they made the legislative adjustments. Now, other aspects of the laws were amended to become consistent with international standards in sentencing. Then you look at the issue of witness protection as a fair trial issue. Now, and you see, these are factors which are affecting judiciaries and countries around the world, not only in Rwanda. But in Rwanda, the impact of the ICTR stimulated change. Now, witnesses, everywhere in the world today where there's problems with criminal prosecutions, where witnesses are not coming forward and giving information to the police or are scared to testify for various reasons. Now, Rwanda faces a problem too. And the question of fear was deep-seated. I mean, witnesses were scared to testify for either the prosecution or the defense. Fears of intimidation, harassment, arrest, even death. Some had fears of exposing themselves to criminal prosecution. Okay, running out of time. I'm suggesting that the tribunal assisted Rwanda in developing a witness protection program. Now, I have 5 minutes more to say. Now, the direct impact, I think, went even beyond Rwanda, beyond Africa. Yesterday, President Johnson referred to a number of countries in Africa that addressed their legislation to bring it into contact. And then we had a situation where it extended to Europe, because when Norway tried to establish its own prosecution, it was subjected to the same rigorous standards by the ICTR as Rwanda. And the first referrals to Norway were refused. Norway, like Rwanda, adjusted its legislation to accord with the standards set by the ICTR. And so then you say that in addition to that, there were what I would call indirect impacts. Because when countries are looking at reform processes, they look at practices which have worked elsewhere. Now, we have issues of the fair trial practices. The issue, how are indictments issued? In a couple of countries, you have the issue of the complicated process of the preliminary inquiry. The ICTR had a process which simplified the process of issuing an indictment considerably, which is a model which is actually being applied in several countries around the world now. Then it had issues relating to the form and the content of the indictment. Now, one of the issues that I think the ICTR stipulated is that the form of indictment was also an issue which is subject to judicial control. And yesterday when I listened to the discussion on the Peter Alanda issue, which I thought suffered from the deficiency of incomplete and inaccurate information, one of the points which is relevant to this very issue had to do with the fact that when a prosecutor issues an indictment, what happens next? The ICTR demonstrated the issue of a judicial investigation as to the extent to which the indictments were defective or not. And there's abundant jurisprudence on that issue. In the Alanda case, the indictment issued by the prosecution was judicially ruled to be defective, and sections were struck out dealing with the issue which have been the subject of discussion yesterday. Then issues of disclosure. Factors which impact directly on the fair trial process, abundant jurisprudence on that issue. Issues to do with major human rights abuses. In fact, the United Nations has declared that the #1 human rights abuse in the world today is pretrial detention. And that surprises people, because who thinks that other things would be more. Now, of course, there are problems that the ICTR have with that. But the issue was, what was done about it? And these matters were judicially investigated and adjudicated upon. And I just refer simply to the case of Kajeli, where when the appeals chamber declared that there was a violation, it created a judicial solution of compensation by ordering that the sentence should be reduced. So I think that fair trial rights have become a hallmark of domestic courts around the world, and the ICTR has augmented the available jurisprudence to which domestic courts can refer. And then you have issues of interpretive guidance and elements of genocide, the definitions of protected groups, issues relating to the mental element of genocide, And I had discussions on that yesterday. But again, when you think in terms of the clarification of the issue as to the difference between mass atrocity generally and genocide in particular. Because you can have mass atrocity involving loss of lives, which is not genocide. And I see that clarified, that no conduct can be described as genocide unless there is a specific intent by the perpetrator to destroy in whole or in part a national, ethnical, racial, or religious group as such. And then guidance on statutory interpretation. The phrase "as such," which might seem superfluous, was in fact created a vital element in the crime, because for acts of constitute genocide, they had to be done with that specific mental intent. I'm cut off at the knees.